All right, good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak to your attorneys before speaking on the record this morning, because everything that we say here is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, please know that attorneys from the Public Defender's Office are present here in the courtroom with me and are available to you by phone. For those of you represented by private counsel, please know that your attorneys also come here to the courtroom with me and are able to address your cases from here. When I call your name, if your attorney is not in the courtroom, you can let me know that and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. This morning, you need to know that I also have in the courtroom with me attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at First Appearances if you are present this morning on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, please know that those cannot be changed or resolved here at First Appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. Before we get started this morning, I would just like to ask each of the jail facilities if any of them have any defendants who they would like to be called out of turn. That would go for Maine, Paul Ryan, Conti, and North Broward. If anyone has someone to be called out of turn, please let me know now.
Main jail, nobody, ma'am.
Thank you. Anyone at Paul Ryan, Conti, or North Broward? Okay. All right, let's go ahead and get started with our list. First up will be Mary Grant.
Main jail, she's approaching.
Thank you, Deputy. Good morning, Ms. Grant.
Good morning.
Ms. Grant, you're before the court this morning on 2 charges. Count 1, touch or strike battery, dating violence. Count 2, possession of cannabis, 20 grams or less. I find probable cause, and I will hear the parties' recommendations beginning with the state at this time.
The state will be asking for a $1,000 bond with no victim contact.
All right, defense? Does Ms. Grant have any prior history, state?
No violent priors, Your Honor, just a 2019 possession of alprazolam and possession of cannabis that is pending, and the judge is unknown.
Broward?
Yes, in Broward County, and just traffic.
What's the date of arrest on the pending case?
Just gonna check, Your Honor. 12206 CF.
Still filed.
It's filed, Your Honor, but it doesn't show me in front of Judge Coleman.
Pretrial is closing at 1. The pretrial office closing at 1?
Yes.
Okay. Before, okay. Okay, I will grant the defense's request, and I will release Ms. Grant to standard pretrial supervision. Ms. Grant, a couple of important things that you need to know. Number 1, there is going to be an order of no victim contact. That means with respect to the alleged victim in this case, you are not to be in the same place at the same time as this person. That also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand?
Yes.
All right. Additionally, since I'm placing you on standard pretrial supervision, you're going to be released today, but you must report to pretrial services in person. If you are released before noon today, then you can go to pretrial today because they're just across the street from the jail. But if you are released after noon, then understand that you must be at the pretrial office before noon tomorrow. If you fail to report to them, as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes.
All right. Thank you, Ms. Grant. Good luck to you.
Romero,
Yes.
Ma'am.
North Broward has someone to be called out turn? Yes, ma'am. Gates, is that what you said? All right, one moment. All right. All right, let's go to North Broward. Good morning, Mr. Gates.
How you doing, Miss Yana?
I'm well, thank you, Mr. Gates. Sir, you're before the court this morning on a total of 6 charges. Counts 1 through 3 are each a separate count of battery on a law enforcement officer. Count 4, resisting an officer obstructing with violence. 5, trespassing on an unoccupied structure or conveyance. And count 6 is a felony probation violation, which has a no bond hold.
Yes.
All right, now the no bond hold will have to be addressed with the division judge within the next few days. I do find probable cause, and at this time, I will hear the parties' recommendations on counts 1 through 4, beginning with the state.
Yes, Judge. Just
All right. Yes.
as far as the defendant's criminal history goes, Judge.
So, I'm sorry, I can't hear you, counsel. You gotta speak.
Oh, I'm sorry. As far as the defendant's criminal history, Judge, there was a 2017 shooting deadly missile, which is currently on probation for. That's 17-13344 CF10A. He has multiple trespasses in 2018, a battery in 2017, a petty theft from 2017, criminal mischief from 2017. Let me see if I can go a little bit up. Judge, in 1995, the defendant pled guilty to attempted murder in the first degree, served 15 years Florida State Prison as a habitual offender.
Yes. Sure did.
Judge, at this time, the state would be asking for a $5,000 bond on each count, and obviously, Judge, for the 2017 probation violation, they'd be held no bond.
All right, and defense, in light of the no bond hold, do you have any objection to that? Okay. All right, so then on, and state, was that your recommendation for 1 through 4, or is that just for 1 through 3?
It's for 1 through 3, Judge. I'm sorry, Judge, and 4.
Okay. All right, in light of the no bond hold, I will set a $5,000 bond on counts 1 through 4. And Mr. Gates, you'll be seeing your division judge within the next few days to address that no bond hold on the probation violation. Good luck, sir.
All right. That's it. Good luck.
Good luck,
Good luck
thank
to
you.
you.
All right, next will be Lindsay Romero.
Yes, sir.
We'll go back to Maine. Thank you. Good morning, Ms.
Good
Romero.
morning, Judge. Good morning, Your Honor.
All right, Ms. Romero, you're before the court this morning on 1 charge of battery causing bodily harm, domestic violence. I find probable cause, and at this time, I'll hear the parties' recommendations. We'll begin with the state.
Yeah, the state would be asking for a $1,000 bond. She had a 2019 battery against the same victim that was declined, and a 2009 petty theft that was declined.
All right, defense?
Excuse me, Your Honor.
Yes.
The defense, I cannot hear, we cannot hear the
Okay.
defense.
Guys, I just need you to speak into the microphone. Sometimes it's hard for them.
State that the two cases that the state mentioned, they were declined, which meant that the state attorney's office themselves, they found if they didn't have no.
I'm sorry, we still can't hear anything. No
Is the
audio.
button on? There you go.
Judge, regarding the 2 cases that the state mentioned, they were declined by the state attorney's office, meaning that they didn't find enough probable cause to go forward on bringing charges against Ms. Romero.
And so I don't believe those should be considered, and under the current circumstances, I believe that a reasonable bond would be an ROR to standard pretrial. Ms. Romero advised that she has never failed to appear. She would be staying with her parents. There would be no contact with the alleged victim, and she has lived in Broward County for 23 years.
Okay. All right, I'm gonna grant the defense's request and place Ms. Romero on standard pretrial supervision. Ms. Romero, there's a couple of important things for you to know. Number one, there will be an order of no victim contact. That means until further order of the court, you are not to be in the same place at the same time as the alleged victim in this case. That also means no phone calls or text messages to this person and no third-party contact or social media contact with that person. Do you understand?
Yes, Your Honor.
All right. Additionally, Ms. Romero, because you're being placed on standard pretrial supervision, that means that you'll be released today, but you must report to standard pretrial supervision within 24 hours. As you probably heard me say earlier, if you are released before noon today, then you can go to the pretrial office today. If not, you need to be there in person before noon tomorrow. If you fail to report to them, as I've instructed you, a warrant will be issued for your arrest. The paper that the deputy is giving you has all the information as to where you need to go. Do you understand?
I do. Thank you, Your Honor.
Okay, thank you, Mr. Romero. Good luck.
Thank you.
Next will be Belinda Boutin.
No problem.
Thank you. All right, good morning, Ms.
Good
Boutin.
morning.
All right, ma'am, you're before the court this morning on one charge of battery causing bodily harm, domestic violence. I find probable cause, and I'll hear from the parties, beginning with the state.
Heroin Priors is a disorderly conduct out of Georgia in 2018, and a 2013 theft out of New Jersey that was adjudicated. Based on her lack of violent priors, state will be asking for a $1,000 bond and no victim contact.
Defense?
Judge, we would be asking for ROR to standard pretrial based on the defendant's lack of serious criminal history. Defendant has advised that she has always shown up to court, and she would have a place to stay in Broward County were she to be released.
That is separate from the alleged victim?
Yes, Judge.
All right, I will grant that request and place Ms. Boutin on standard pretrial supervision. Ms. Boutin, there's a couple of important things I need you to know. Number one, there is going to be an order of no victim contact. I'm sure you discussed that with your attorney already, but I need you to understand that order means until further order of the court, you are not to be in the same place at the same time as the alleged victim in this case. If you reside together, that means that you have to find someplace else to stay for the time being. That order also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right. Additionally, Ms. Boutin, because you're being placed on standard pretrial, you're going to be released today. But you must report to pretrial supervision by noon tomorrow. The deputy has given you a piece of paper that has instructions on where you need to go and what you need to do. But it's very important that you understand if you fail to report to them, as I have instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay. All right. Thank you, ma'am. Good luck.
Thank you.
Next will be Cynthia Cornelio Carbajal. Thank you. No. Deputy, do you have Cynthia Cornelio Carbajal?
She's at Paul Ryan.
Oh, okay. Let's go to Paul Ryan. Thank you. Okay, and nobody's at Paul Ryan. Is there anybody at Paul Ryan? Okay. Sheila, what are you showing for her for confinement? I will put her on recall. Can someone call Paul Ryan and find out what's going on with that one? I'll keep going. Next will be Amy Cogan Austin. Facilities, Ms. Austin.
Good morning, Judge.
Thank you. Good morning, Ms. Austin. All right, Ms. Austin, you're before the court this morning on one charge of aggravated battery causing bodily harm or disability, dating violence. I find probable cause. And at this time, I'll hear the parties' recommendations. We'll begin with the state.
Judge, there was a 2016 misdemeanor leaving the scene of an accident, DWLS, which he pled no contest for, received an adjudication time served. A grand theft auto in 2014, which he was sentenced to 29.03 months Florida State Prison. That was in addition to a 2013 felony battery with priors, an aggravated fleeing, eluding as well. She received the 29 months. 2011 AGBAT, 2 counts of AGBAT, deadly weapon, in which she received 1 year Florida State Prison as a habitual offender. 2011 grand theft auto, in which she received 364 days, followed by 2 years probation as well. And 2008 grand theft auto, in which she received 364 as well, followed by 18 months probation. Judge, given the fact that the defendant has a violent history, the state would be asking for a $5,000 bond and a no contact with the victim in this case.
Defense? Speak into the mic. Make sure the button's on.
Is this $5,000 for counts one, just for the whole thing?
On Ms. Austin, yeah, there's just one count.
Just one.
5,000
Oh, right,
and no
right.
contact.
Okay. I would be asking for an ROR to level 2 with a GPS monitor, Judge. Ms. Austin cannot afford a bond, and I believe she advised me that she has never failed to appear for court in Broward County.
Based on the level of violence that's been alleged in this case and the prior history, I'm not inclined to grant the request for an ROR at this time. I'm not asking you to tell me what your discussion with her was, but do you have an alternate recommendation? What was Ms. Austin's most recent prior?
Judge, in 2018, she was charged with grand theft auto. The state declined it. But other than that, it was a 2016 and 2017. 2016, it's 1610537 MM10A. It's a misdemeanor leaving the scene of an accident with property damage, DWLS. There, in 2017, there was looks like a battery that was declined as well. But 2015 was her last felony charge that she actually pled to, in which she received, like I said before, 29 months Florida State Prison, in which she pled out back in September 2015.
I'm gonna set the bond at $3,000. There will be an order of no victim contact. Ms. Austin, it's very important for you to understand this no contact order means until further order of the court, you are not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All
Thank
right,
you.
thank you. Good luck.
Rivera?
Yes? 5 minutes? Okay, no problem. Thank you. All right, Claudia Rivera. Okay, good morning, Ms. Rivera.
Good morning, Your Honor.
All right, Ms. Rivera, you're before the court this morning on a misdemeanor violation of probation. I find probable cause. I see the bond is presently set at $5,000. I will hear from the parties on this. We'll start with the defense.
Judge, we would be requesting an ROR to standard pretrial. Ms. Rivera is not able to afford a bond. She advised that she hasn't picked up any criminal charges for a while, which hopefully will be confirmed by the state. She's lived in Broward County for, I believe, around 30 years. And I think she had one prior failure to appear, but I also think it should be noted that on the PC affidavit, it stated that Miss Rivera actually self-surrendered at the main jail. So I think that should be considered.
State, what's her history?
Judge, I would just note that the warrant that was issued was from 2019, almost a year ago.
Yes.
Since this case, it looks like the case concluded from, there's a 2007 driving while license is suspended, which she pled out to with a withhold. In 2009, Judge, she was given a withhold for 2 counts of possession of, one count of possession of clonazepam, 1 possession of alprazolam, and 1 possession of diazepam. There's a possession of cocaine as well in 2010, which she pled no contest to. Again, she was given a withhold. On all of those cases, Judge, she was given 18 months probation. In 2010 as well, Judge, she received an adjudication on a driving while license is suspended misdemeanor. And we also have before the court the 2019 driving while license is suspended. It's a misdemeanor, but it's a habitual offender charge, which is still open. And so I think,
Are there any failures to appear in that case?
let me take a quick look, Judge. No, Judge, she was arrested on March 15, 2019. The state filed this information on the same day. Well, it looks like it was given to us, in which we then filed the information. And there's been only an arraignment from April 3rd, 2019. I don't even see a future date on this case, Judge, but I don't see a no info. Driving while license is revoked. I'm sorry, Judge, not DWLS, but. And we filed that 3/15/2019.
All right, well, since this is a violation of probation, I'm not going to put her on pretrial supervision. I will consider an alternative bond recommendation if the defense has one.
Ms. Rivera, is there any amount of bond that you can afford?
Right now. Or, sure.
Say it one more time.
Oh, not right now.
All right, well, I'm gonna set the, I'll reduce the bond and set it at $1,000. And hopefully Ms. Rivera will be able to find someone to assist her in posting that bond with the services of a bondsman. All right, thank you. Good luck, Ms. Rivera.
Thank you.
Susan Ricard.
Main jail, she's approaching.
Thank you. Good morning, Ms. Ricard.
Morning.
Ms. Ricard, you're before the court this morning on one charge of aggravated battery on a person 65 years of age or older. I find probable cause, and I'll hear recommendations beginning with the state at this time.
Judge, the only criminal history that I see in Broward County is a 2014 disorderly intoxication. I would just note that the facts in this case are pretty disturbing, considering the allegations that were made by witnesses that were at the scene, considering the times in which we're currently having to deal with. Judge, I would ask the court for $2,000 bond and level 2 pretrial with no contact with the victim whatsoever. I also note in the probable cause affidavit, Judge, that the victim was wishing that the defendant stay in the jail because she does fear that she will be attacked again.
Right,
Judge,
defense.
Judge, defense would be requesting a $1,000 bond. I don't believe Ms. Ricard has ever failed to appear in Broward. She's lived here since the 1970s. And while the current allegations may be concerning, these are just allegations at this point. Ms. Ricard is presumed to be innocent. And also considering the fact that Ms. Ricard, she was born in 1952, given the current situation with the coronavirus, I believe that there's a significant safety interest in Ms. Ricard being released, Judge.
Well, I believe the alleged victim has a significant safety interest as well. What I'm more concerned with than the monetary bond is the no contact order. It does appear that these two individuals are neighbors. I'm not sure what the proximity of the apartments are within this building, but if she is placed on a GPS monitor, that could pose an issue, so I'm not sure if you've been able to discuss that with her.
Ms. Ricard, do you live near the alleged victim in this case?
She lives at the other end of the building.
The other end of the building?
Yes.
Okay, thank you. And how far is that?
God, I don't know. I don't know how to tell, like, 3 times as long as this wall, maybe?
Okay, do you have somewhere else that you could stay?
Well, I not really. I mean, I rarely leave the house nowadays anyway because of this corona thing.
Oh,
And I must, if I may say so, I know you told us not to say anything.
Ms. Ricard, don't
but
say
she-
anything. Ms.
Ms.
Ricard,
Ricard.
do not say anything about the facts of the case. That's not for today. What I'm trying to
Okay.
determine, what your attorney is trying to determine right now, is the proximity of you to the residence of the alleged victim. Because if I am going to allow you to be released, I may place you on a GPS monitor, and that would include a 500-foot stay-away order from this person. I don't know what the layout of your apartment complex is, so I'm trying to determine if you will be able to return home or if you will need to find someplace else to stay temporarily. Do you
How
understand?
long would I?
Ms. Ricard,
How long-
I'm sorry for cutting everyone off.
That's all right.
Do you know around how many doors are in between your place and the alleged victims?
2, 3, 4, 5, 6, about 8.
8 doors?
About 8.
Okay, all right, thank you.
I never go down to that end of the building. This happened right outside my door.
All right, thank you, Ms. Ricard.
I mean, how long would I have to stay somewhere else?
Well, Ms. Ricard, based on everything that's going on right now, I don't have a definite timeline to tell you. It would be until your division judge says otherwise, which that could be, that could be a few weeks at this point.
I could probably find a place, but it might take me a few days.
Pre-trial, you have any recommendations on this?
I don't even know this woman.
Ms. Ricard, one moment, please.
Oh, God.
Well, if I put it on her GPS, she may be able to. They'll verify that before she's released. Okay. All right, so here's what I'm gonna do. I will set the monetary bond at $1,000. I am going to order that Ms. Ricard be placed on pretrial supervision with a level 2 GPS monitor. that will include a no victim contact order. Ms. Ricard, I was just discussing with pretrial the logistics of how we're going to do this. Pretrial supervision are the ones that will fit the GPS monitor for you, okay? They will map out the residence location to see if it meets the 500-foot minimum stay away requirement. If pretrial verifies that that's fine, then you'll be able to return home. If they are not able to verify that and they say that it's less than 500 feet and it doesn't meet their requirements, then they will advise you and you will have to find someplace else to stay. Do you understand that?
Yes, ma'am.
Okay.
The only thing is, what if she walks by my
Right, so
apartment?
pretrial supervision is gonna have to handle whether it meets their requirements or not, okay?
Okay,
So they will let
okay.
you know that. Now, I need you to
Okay.
understand that pretrial will advise you of the requirements as far as where you're going to be going, but in the meantime, I need you to hear from me. The no contact order means no being in the same place at the same time as this person. As you just heard me say, since you will be on the GPS monitor, that will include the 500-foot stay away order, all right? So pretrial, once again, they'll advise you on where you need to be. That no contact order also means whether you know this person or not, no phone calls or text messages, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
Okay, all right, thank you very much. Good luck.
Thank you, thank you.
All right, next will be Erin Emmerling. North Broward. Okay, all right. Good morning, Miss Emmerling.
Good morning.
Miss Emmerling, you're before the court this morning on a felony violation of probation. I find probable cause, and Miss Emmerling, this has a no bond hold on it, which means that you will go before your division judge, hopefully within the next few days, to address that matter.
Okay.
All right, good luck, ma'am.
Thank
You're
you.
welcome. All right, is Grace Johnson still medical? Okay,
Yes.
thank you.
Go ahead.
Shamilette Rose?
Yes, ma'am.
All right, good morning, Miss Rose.
Good morning.
Miss Rose, you're before the court this morning on one charge of robbery without a firearm or weapon. I find probable cause, and at this time, I'll hear the parties' recommendations, beginning with the state.
May I just have one moment, I just had to grab the phone.
Go ahead.
Monday. This court the weekend view? This court the weekend?
Judge, in 2019, she pled no contest, she was adjudicated, received time served on a paraphernalia case. There's a 2018 resisting without violence, no valid DL, and failure to comply with an order in which she pled no contest to. Looks like she received a withholding court costs on that. However, Judge, in 2016, she received 240 days Broward County Jail, followed by 42 months probation. She pled that out in 2018. It was a robbery, no weapon. It's 16835 CF10A. She also pled no contest to a battery, which is the same case. In 2015, Judge, she also pled no contest to a disorderly conduct. Given the defendant's violent prior history, recent prior history, the state would be asking for a $7,500 bond, no contact with the victim, Erica Hollander, and no contact with the co-defendant, Stefan Brown.
She's still on probation in that 2016 case? What was that done?
No, Judge.
Okay. All right, defense?
For clarification, the robbery that was mentioned, was this the underlying charge for this case, or was it, I'm sorry,
She has a prior robbery.
Okay, a prior robbery including this one?
This is the second, this is the second
Okay, my
robbery that's
mistake.
alleged against her. In her 26 years of life.
Judge, given that Ms. Rose is indigent and financially unable to post the bond, we would be requesting an ROR to level 2 with a GPS monitor. Ms. Rose advised that she has her own place. She's lived in Broward County for at least 15 years. She's had one failure to appear, I believe, a couple of years ago, but I don't think that there was notice for that case. And given that she has a place to stay, I think I also talked to her, there would be no contact with the alleged victim in this case. We would be asking for ROR to level 2 with the GPS.
All right, based on the history and the present allegations, I'm not comfortable with granting that recommendation. I will set the bond in this case at $3,500, and there will be an order of no victim contact. Ms. Rose, it's very important for you to understand that no contact order means until further order of the court, no being in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
All right, thank you. Good luck. Yes, that's correct. Next will be Lawrence Lawson.
Do you want to call Miss Cornelio?
I'll call her next.
Ryan?
I'll call her next.
Okay.
All right. Good morning, Mr. Lawson. Mr. Lawson, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I'll hear from the parties, beginning with the state at this time.
Your Honor, based on his prior allegations, the state will be asking for a $3,000 bond. Mr. Lawson had a 2017 domestic violence battery that was no pros with the same victim. She failed to show up for trial. He has a 2015 disorderly intoxication, 2008 domestic violence battery, different victim that was either declined or no prost, a 2007 battery that was declined, a 2005 battery out of St. Lucie that was dropped, and a 1994 burglary, and a battery that was a withhold, an aggravated assault that was dropped in Broward County. So based on his violent priors, the state will be asking for a $3,000 bond and no victim contact.
Thank you. Defense.
Judge, defense will be asking for $1,000 bond, Judge. All these charges most of these charges that the state brought up, they were declined or no pros. So as far as convictions go, I believe we should only be talking about the 2015 disorderly conduct and the Berg bat, which is obviously very concerning, but this is from 1994, so this would be 26 years ago, Judge. Mr. Lawson, he's lived in Broward County for, I believe, 5 years. I don't believe there would be any contact with the alleged victim, and given the current conditions right now with the coronavirus, Mr. Lawson would appreciate a chance to be released.
The monetary bond will be set at $1,500. Mr. Lawson, there is going to be an order of no victim contact. That means until further order of the court, you are not to be in the same place at the same time as the alleged victim. If you do live together, you will have to find someplace else to reside for the time being. That order also means no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
I have one question, Your Honor.
Yes, Mr.
If
Lawson.
that victim moves out that residence, I can return, correct?
If the alleged victim moves from the residence, then yes, you may return.
Okay.
Okay? Thank you. Good luck. I'm going to the mail. All right, next we're going to Paul Ryan so I can recall Cynthia Cornelio Carvajal. All right.
Cynthia's fighting interpreter, Your Honor.
Okay. Well, do we have the telephone number for the interpreter of the day? I'm sorry. All All right. Deputy, I'm gonna go to the next case while they get in touch with the interpreter's office, and I'll call her back up in just a moment, okay? Just give me 1 minute. Thank you. Once you guys get the number, then I'll come back to her. Okay, then next I'm gonna call up Horace Hewitt. Mr. Hewitt at Maine. All right, good morning, Mr. Hewitt, thank you. Mr. Hewitt, you're before the court this morning on 4 charges. Count 1, domestic battery by strangulation. Count 2, aggravated battery on a person 65 years of age or older. Count 3, possession of cannabis 20 grams or less. And count 4 is a felony warrant for violation of pretrial that has a no bond hold. I find probable cause, and the no bond hold will have to be addressed with Mr. Hewitt's division judge, but I will hear the parties' recommendations on counts 1 and 2 at this time.
Judge, that's here for me.
Start with the state court.
Judge, the court already mentioned the 2019 possession of cocaine with intent, which is filed. That's 197895 CF10A. In addition, Judge, the defendant pled out to a trespass back in 2018 for, which is 188363 and then 10A. The defendant has a has a long history of violence here, Judge. There's a battery in 2017, which he pled no contest to, and received 270 days Broward County Jail. Possession of PVP, which had violations of probations, which he received 180 days Broward County Jail, followed by 5 years probation. He has a delivery of cocaine in 2011, in which he also received 180 days, followed by 4 years probation. He was sentenced as a habitual offender in that case. There's an additional 2007 delivery of cocaine, in which he received 43.8 months Florida State Prison. He pled no contest to a disorderly conduct in 2007 as well. There's additional possessions of cocaine with intent, which he received 41.1 months Florida State Prison in 2002. Resisting with violence, Judge, in which he received 38 months Florida State Prison, which is 975855 CF10A. Aggravating fleeing and eluding, resisting with violence, and in 1996, in which he also received 38 months Florida State Prison. A fleeing and eluding again in 1995, which he received 6 months probation. And a robbery with a firearm in 1989, in which he received 6 years Florida State Prison. Judge, the state would be asking for a $7,500 bond on counts 1, on count 2, and well, that's all. The other ones are a $100 bond and the no bond. And no victim contact, no return, obviously, Judge.
Right. Defense? Okay. In light of the no bond hold, I will set the bonds on counts 1 and 2 at $7,500. Though Mr. Hewitt does have the no bond hold, in an abundance of caution, I will place a no victim contact order. Mr. Hewitt, it's very important that you understand the no contact order means until further order of the court. No being in the same place at the same time as the alleged victim. If you do reside together and you become eligible for release, then understand that means you have to stay someplace else for the time being. The no contact order also means no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand?
Yes, sir.
All right, thank you, sir. Good luck. Okay, did we get a telephone number for the station? Okay. It's not for us. It's not for us. Okay, what's the number? Okay, did you get the name? I'll go back to Paul Ryan. Let me just get the interpreter on the line.
Hello?
Good morning, Miss Sands. This is Judge Cawthon. How are you this morning?
Hi, good morning, Judge. I'm fine. How are you?
I'm fine, thank you. I was told that you're able to be my interpreter I have 2 cases here at first appearances this morning. Is that correct?
I'm available, absolutely. I don't think they told me about your cases, but I'm available. It doesn't matter. I have a case with Judge Kaplan at 10:30.
Okay, well, I only have 2 cases right now if you're able to assist me right at the moment.
Yes, I can. Of course, Judge. Of course.
Okay, thank you so much.
Yes.
Just let me know when you're ready.
Okay, just 1 second. Okay.
Okay, so I have
ready.
2 of them, so I'll give you both of the names ahead of time, okay?
All right. Wonderful. Thank you.
All right, the first is going to be Cynthia Cornelio Carbajal,
Yes.
Okay.
and the second is going to be Otavera Reyes Roa.
Altavera Reyes Rojas.
Yes, it's
Oh.
ROA is what I have. ROA.
Oh, Roa. Okay.
Okay, so before I get started with Miss Cornelio, I'm just going to swear you in over the phone. So,
Okay.
do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
Yes, Judge, I do swear.
Thank you. And will you just state your full name for the record?
Yes, my name is Sandra Bryan, Bryan.
All right. Thank you, Miss Bryan. Okay. All right. And I have Miss Cornelio here. Good morning, Miss Cornelio.
Buenos días, señora Cornelia. Buenos días.
Buenos días.
Good morning.
Miss Cornelio, you're before the court this morning on one charge of touch or strike battery, domestic violence.
Señora Cornelio, ¿está usted delante del tribunal esta mañana por un cargo de tocar o lesionar violencia doméstica?
I find probable cause.
Encuentro que ha habido causa probable.
And at this time, I'm going to hear the parties' recommendations, beginning with the state attorney.
Y en este momento voy a escuchar las recomendaciones de las partes, comenzando con el Estado.
Your Honor, the state will be asking for a $1,000 bond. Ms. Cordelio does not have any Florida priors. However, she is from Honduras, and no victim contact.
Señora juez, estamos pidiendo en este momento $1,000 de fianza. La señora Cornelio no tiene antecedentes penales, pero es del país de Honduras.
All right, defense.
Defensa.
If I may speak with Ms. Cornelio.
That's fine.
Ms. Cornelio, do you have an address that you would be able to stay at if the judge were to let you out?
Necesito dirigirme a la señora Cornelio. Señora Cornelio, ¿tiene usted una dirección donde usted podría quedarse si le concedieran la libertad?
Sí.
Yes.
And where would this be?
¿Y entonces dónde sería?
La dirección es 1801 Northwest 6TH Avenue, Pompano Beach, Florida.
Permiso, un momento. 1801 Northwest, ¿cuál es la calle?
6th Avenue.
Okay, yes, I do have a place. It's 1801 Northwest 6th Avenue, Pompano Beach.
And would this be with the alleged victim in this case, or are you going to be separate?
I'm sorry, can you repeat,
Will you-
interpreter?
Does the alleged victim in this case reside at this address?
Señora Cornelio, la víctima, la alegada víctima en este caso, ¿vive en esa misma dirección?
Sí, pero ellos ya se mudaron.
Yes, but she moved.
Okay, so she's no longer living at that address?
Está bien, entonces ya ella no está en esa dirección?
No, ya no está.
No, she's no longer there.
And is there any amount of bond that you can afford?
Señora, ¿hay alguna cantidad de fianza que usted podría pagar?
No sé, $100.
I don't know, $100?
Y después por pago el otro, no sé.
and then afterwards maybe pay the other amount? I don't know.
All right, thank you.
Gracias.
Judge, given Ms. Cornelio's lack of criminal history, we would be requesting an ROR to standard pretrial. This court heard from Ms. Cornelio. She does have an address she would be able to stay at, and this would not be with the alleged victim, as the alleged victim has moved away. And I don't
Señora,
believe,
juez,
the fact that Ms. Cornelio is from Honduras and not from here, I don't believe that should prejudice her in terms of getting out.
Señora juez, debido a el hecho de que la señora Cornelio no tiene antecedentes penales y ella sí tiene una dirección donde podría irse si tuviera la libertad y la víctima no estaría ahí, pedimos concederle la libertad sin fianza. El hecho de que venga de Honduras no tiene que ver nada con este caso. Gracias.
And the state would argue that the fact that she is from Honduras shows her lack of ties to the community. On the booking sheet, it just shows she's been here for 72 months. Therefore, we will be asking for a monetary bond.
I believe that.
Señora juez, el hecho de que ella es de Honduras demuestra la falta de enlaces con la comunidad. Ella ha estado aquí 72 meses ya.
Okay, just one moment. I need to confirm something with confinement status.
Necesito confirmar con el otro departamento de confinamiento, del estado de confinamiento.
Does Ms. Cornelio have an ad charge that is not before me today but will be?
La señora Cornelio tiene otro cargo que se va a añadir, pero que no está presente ahora mismo.
No.
Okay. Confinement status has advised me that Ms. Cornelio is going to be ad charged with an immigration hold.
Acaban de informar que la señora Cornelio lo van a detener con otro cargo de inmigración.
That means that will likely come on our docket tomorrow morning.
Lo más probable, eso significa que estará en nuestra lista de las causas para mañana por la mañana.
I'm bringing that up because I want everyone to understand that if the immigration hold does come in place.
Sorry, go ahead, Your
That's
Honor.
okay. If the immigration hold is placed, then whether she posts her bond or not, she will have to remain until that issue is addressed.
Lo menciono ahora porque si llega a ser así, la detención con inmigración, ella seguirá detenida con la detención de inmigración, no obstante los otros cargos.
All right. Does the defense wish to be heard further?
¿La defensa quiere hablar?
No, Your Honor.
No, su señoría.
All right. So I will set the monetary bond at $1,000.
Voy a fijar la fianza monetaria a $1,000.
And there will be an order of no victim contact.
Habrá una orden de no tener contacto con la víctima.
Ms. Cornelio, it's very important that you understand this means you are not to be in the same place at the same time as the alleged victim.
Señora Cornelio, es muy importante que usted comprenda que usted no puede estar en el mismo lugar a la misma hora que la víctima.
That also means no phone calls or text messages to this person.
Eso también significa que no puede hacer llamadas telefónicas ni enviar mensajes de textos a la víctima.
And no third-party contact or social media contact with this person.
Y también significa que no puede tener contacto por medio de una tercera persona ni tampoco por los medios sociales, redes sociales.
Do you understand that, ma'am?
Señora, ¿usted comprende esto?
Sí.
Yes.
All right. And Ms. Cornelio, I just want to advise you, since I've been told that you are going to be ad charged with the immigration hold, you will probably be back here tomorrow morning.
Y también, señora Cornelio, como me acaban de informar que se le va a agregar un cargo de la inmigración, lo más probable es que mañana otra vez va a estar delante de mí.
Good luck to you, ma'am.
Okay. Eso, señora.
Okay.
Thank you.
Buena suerte.
Gracias.
All right.
Thank you.
And then our other case that requires a Spanish interpreter is on page 2, and that is Atavera Reyes Roa.
Main jail, ma'am.
Thank you. All right. Good morning, Ms. Reyes.
Buenos días, señora Reyes.
Buenos días.
Judge, and I do have a
Morning.
probable cause up.
All right. Ms. Reyes, you're before the court this morning on 4 charges.
Señora Reyes, está delante del tribunal esta mañana por 4 cargos.
Count 1 is aggravated battery causing bodily harm or disability.
El primer cargo es agresión con agravantes causando daños corporales graves.
Count 2, touch or strike battery, domestic violence.
El cargo 2 es tocar o lesionar, agresión, violencia doméstica.
Count 3 is child neglect without great bodily harm.
I'm sorry, didn't hear the third charge, Your Honor.
It's child neglect without great bodily harm.
El tercer cargo es descuido de niños sin daños corporales.
And count 4 is resisting an officer or obstructing without violence.
Y el cargo 4 es resistir un policía sin violencia.
And I will hear the defense's argument as to probable cause at this time.
Thank you, Judge.
Escuchar el argumento de la defensa.
I do have an argument for probable cause as to the aggravated battery count. I've reviewed the facts in the probable cause affidavit, and it's the defense's position that there are no facts indicating that the defendant, in committing the battery, intentionally or knowingly caused either great bodily harm, permanent disability, or permanent disfigurement, or used a deadly weapon. In the probable cause affidavit, there's a mention of a key to a vehicle.
Slow down. So you have the interpreter.
I forgot.
All right, go ahead, let her catch
Tengo
up.
un argumento acerca de los agravantes, agresión con agravantes. En el affidavit de causa probable no aparece ningún hecho con respecto a que la acusada intencionalmente causó una discapacidad permanente ni que usó un arma mortífera. Continue.
It's my argument that the key that was alleged to have been used is not a deadly weapon. A weapon is defined, a weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. It's my argument that
Mi argumento es que la llave no es una arma mortífera. Se define un arma mortífera si se utiliza de tal forma para causar la muerte o una discapacidad permanente grave.
so as to this count, it's my position that the key was not used in a way to produce death or great bodily harm.
Así que mi postura es que la llave no se usó de una forma para causar muerte ni daños con agravantes mortíferos.
Okay, and we'll go to the state for response.
Yes, Judge, I mean, the facts in the probable cause affidavit indicate that the key was used, force was used with this key. Lacerations were found on the victim's face. State's position is that is disfigurement, permanent disfigurement. It's an issue of whether or not right now there's enough probable cause, which is quite a low standard compared to, I think, what the defense is arguing, which is something for a jury to decide whether or not a key is a deadly weapon. I think that there's probable cause to exist that the charge is appropriate.
Nuestra postura es, según la affidavit de causa probable, que sí se reflexionaron o se vieron laceraciones en la cara para causar un disfiguramiento permanente y es suficiente para el affidavit de causa probable y depende de un jurado para decidir si una llave es un arma mortífera o no.
All right, for today's hearing purposes, I am going to make a finding of probable cause.
Para el propósito de la audiencia de hoy, sí encuentro que ha habido causa probable.
And at this time, I will hear the parties' recommendations as to bond, beginning with the state.
Yes, Judge.
Comenzando con el Estado, ahora voy a escuchar las recomendaciones de la fianza.
Judge, as far as the defense criminal history, I see no criminal history in here at all. There's none in Broward County, and I see none in the country. I do note, however, that she is originally from the Dominican Republic, has only resided here for 5 years. Judges,
Veo que ella no tiene antecedentes penales, ninguno en el condado de Broward ni en el país. Ha venido de la República Dominicana, ha estado aquí ya 5 años.
okay, Judge, for that reason, the state would be asking the court to, for count 1, a $2,000 bond.
Y por esa razón, el Estado estaría pidiéndole al tribunal, por el cargo número 1, una fianza de $2,000.
Count 2, $500.
En el cargo 2, $500.
Count 3, $1,000.
En el cargo 3, $1,000.
And pretrial 2, with no contact with the victim.
Y supervisión previa a juicio sin contacto con la víctima. También el cargo 2.
All right, and at this time, I'll go to the defense.
Ahora la defensa.
Go ahead.
Hello, Ms. Reyes. Ms. Reyes, are you able to afford any amount of bond?
Mire, señora Reyes, ¿podría usted pagar alguna cantidad para fianza?
Ahora mismo no tengo dinero, solamente mantengo mis 3 niños sola.
Right now, I have no money. I have to support my 3 children by myself.
And Ms. Reyes, do you have an address you would be living at if the judge were to release you?
Mire, señora Reyes, usted tiene una dirección donde usted se iría a vivir si la juez le da su libertad, le concede libertad.
Sí,
And this would be apart from the alleged victim?
Y esta dirección sería aparte de la alegada víctima.
sí,
Yes.
And Ms. Reyes, do you have a passport?
Señora Reyes, ¿usted tiene un pasaporte?
sí.
Yes.
All right, thank you, Ms. Reyes.
Sorry?
Thank you, that would be all.
Oh, gracias, señora Reyes. Eso es todo.
Ahora la juez va a decir.
All right, Deputy, will you just turn the mic off for one moment?
Momento.
Thank you.
Judge, Ms. Reyes is currently not able to afford the bond that's presently set. Your Honor heard from Ms. Reyes. She has 2 children that she is providing for. She does have an address that she will be staying at that will be apart from the alleged victim. If Your Honor does have a concern about Ms. Reyes, even though she's lived in Broward County for 5 years, if the court does have a concern, then we would just be requesting that a condition be added that she surrender her passport while this case is pending.
Mire, señora juez, ya usted oyó que la señora Reyes no puede pagar ninguna fianza. Ella tiene una dirección donde se podría ir aparte de la víctima. Y si a la corte todavía le preocupa a la señora Reyes, aunque ha vivido aquí 5 años en Broward, le pedimos que simplemente añade una condición más.
And I would finally be emphasizing that she has no criminal history whatsoever.
Y enfatizo que no tiene ningún antecedente penal y que también tiene niños para mantener 2 niños.
All right. In light of all of the information that has been provided, I am going to release Ms. Reyes to pretrial supervision.
En vista de toda la información que se ha presentado, le voy a conceder la libertad a la señora Reyes bajo la supervisión previo a juicio.
However, that will be with a level 2 GPS monitor.
Eso será con un monitor electrónico nivel 2 de GPS.
Counts 1 through 4 will be in ROR.
En los cargos del 1 al 4 se le concede libertad sin fianza.
Ms. Reyes, it's very important that you understand there will be a no victim contact order.
Mire, señora Reyes, es muy importante que usted comprenda que va a haber una orden no poder tener contacto con la víctima.
I am not, for the record, I am not applying that to the minor child in this case.
I'm sorry, there was no, I can't, the interpreter didn't hear that.
The no contact order does not apply to the minor child.
Mire, la orden de no contacto no se aplica al niño menor.
It will apply to Ariel Montero Salazar.
Se aplica a Virgilio Montero Salazar.
Ms. Reyes, that means that you're not to be in the same place at the same time as this person.
Señora Reyes, esto significa que usted no puede estar en el mismo sitio a la misma hora que esa misma persona, ¿sabe?
Since you will be wearing a GPS monitor, that will mean that you have to stay at least 500 feet away from this person.
Como usted va a estar
Una
con el monitor
pregunta.
electrónico de GPS, no se puede acercar a menos de 500 pies de distancia.
The no contact order also means no phone calls or text messages to this person.
La orden de no contacto significa que no se puede hacer llamadas telefónicas ni enviarle mensajes de textos a esta persona.
And no third-party contact or social media contact with this person.
Tampoco puede haber contacto por medio de una tercera persona por las redes sociales o los medios sociales.
Ms. Reyes, do you understand what I've explained to you?
Sí,
Señora Reyes, ¿usted comprende lo que le acabo de explicar?
sí.
Yes.
Yo tengo una pregunta.
I have one question.
All right, what is it?
Ellos me
¿Y cuál es la
podrían
pregunta?
ellos me podrían devolver mi bebé de 5 meses que apenas lo estoy amamantando.
Can I have my child, the 5-month-old, back because I'm still breastfeeding?
Ms. Reyes, you may have contact with the child. However, in order to do that, you will not be able to have any direct contact with the alleged victim. So I will
Señora
allow...
Reyes, usted puede tener contacto con la criatura, pero usted no puede tener contacto directo con la víctima.
I will...
Okay, o sea, mi pregunta es que si se lo pueden devolver a mi hermana o a alguien para yo seguir amamantando a mi bebé que está muy pequeñito y ellos ni siquiera nunca saben ni siquiera qué leche toma mi bebé ni nada porque solamente he sido yo para él.
My question is then, can someone bring the child to my sister or to someone else's home so that I can breastfeed? Because no one knows what milk she drinks. She doesn't drink any other milk, so I can keep breastfeeding.
Yes, as long as there is a third person that acts as the intermediary, then that is fine, as long as it's not you having direct contact with the person that we discussed. Do you understand?
Okay, se puede hacer por medio de una tercera persona que actúe como el intermediario, siempre y cuando que usted no tenga ningún contacto directo con la persona que acabamos de hablar. ¿Usted comprende, señora?
Okay, entonces si me dejan en libertad hoy, lo podrían hacer hoy porque necesito estar con mi bebé.
So if I'm able to be released today, can we start this today because I need to be with my baby?
As long as you use a third person, which I've explained to you, then you will be able to do that.
Siempre y cuando que usted use una tercera persona, como yo le expliqué, se podría hacer.
Sí, a mí no me interesa tener ningún contacto con ninguno de ellos y todo lo que ellos dijeron es mentira. Yo nunca agredí a nadie.
Okay, I don't have any interest in having contact with that person, and everything that they said was a lie. I never hurt anyone.
Okay, thank you.
All right.
We're done.
Good luck, Ms. Reyes.
That's it for the
All right.
interpreter?
Is there anyone else that needs a Spanish interpreter at Maine, at Paul Ryan, at Conti, or North Broward?
Ma'am, no.
Okay. Anyone at Paul Ryan, Conti, or North Broward that needs a Spanish interpreter before I let her go? Okay. All right, Ms. Bryan, thank you very much. I appreciate the help.
Okay, thank you, Judge. Have a good day.
You too. Thank you.
Bye.
All right. Now, continuing down our list, next I have Jesus Carrion. Is he still medical? Okay, yes. All right. I did make a probable cause finding in his case, so we're just waiting for him to be reset for bond when he's available. Yes, so Mr. Carrion, just for the record, on Friday we addressed Mr. Carrion's case at our first appearance hearing. The public defender's office was willing to waive his appearance for probable cause purposes. Once we got into a discussion about bond, there were some arguments being made, and so they were not willing to waive his appearance for bond purposes. So when he is ready, then we will have him reset to address bond. All right, next will be John T-Sax. Okay, is on Mr. T-Sax's case, is the public defender's office willing to waive his appearance to proceed? For both? For that one? Okay, will the state please provide a copy of the probable cause affidavit on that case to the public defender's office.
What's it, Judge? I'm sorry?
It's TKACS.
This is my only copy, so if you want to.
All right, and I will, I'll put it on a recall when you're ready. Just let me know. We'll come back to it. All right, next will be for Rondo Randall.
Rangel is approaching.
Thank you. Good morning, Mr. Randall.
Good morning.
Mr. Randall, you're before the court this morning on a total of 3 charges. Count 1 is for criminal mischief between $200 and $1,000. Count 2 is a traffic capias related to a charge for operating with a suspended driver's license, second offense. Count 3 is a municipal ordinance violation for violating the city's stay-at-home order. I find probable cause for these charges, and I will hear from the parties. We'll begin with the state.
Judge, there's a 2019 misdemeanor violation of an injunction which the defendant pled guilty to, received an adjudication time served. He received an adjudication time served on a trespass structure 2018, that's 18-12367 MM10A. Criminal mischief, I'm sorry, Judge, that was declined. I won't bring that up, but I will bring up a 2016 Berg structure unoccupied in which the defendant was sentenced to 29.3 months Florida State Prison as a habitual offender. And it appears, Judge, there is a filed uttering forged instrument from 2016. It says it's still open, but let me just double check. No, that's closed, Judge.
Okay.
Other than that, there's the pending traffic case, which is 206529 TC30A, which is in front of Judge Francois, which is operating with a suspended license, second offense.
State seeking anything beyond the bonds that are set?
No, Judge.
All right, defense?
Judge, I've spoken with Mr. Randall. Mr. Randall is not able to afford the bond. We would be requesting an ROR to pretrial level 2 with a GPS monitor, considering the bird count. I will add that his other charges aren't serious, and he is a lifetime resident of Broward County.
All right, in light of the current allegations and the history that's been presented from Mr. Randall, I'm not comfortable with granting that request at this time. I am going to leave the standard bonds in place on counts 1 and 2. Additionally, there will be an order of no victim contact as well as a no return order. Mr. Randall, that means that you are not to return to or go to the location that is at issue in this case. The no contact order means that you are not to be in the same place at the same time as the alleged victim in this case. That also means no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that?
Yes.
Thank you. Next will be Jairo Rodriguez Aparicio. Reset? Okay. We'll reset him to tomorrow. Lorenzo Jones.
Rangel is approaching.
Thank you. Good morning, Mr. Jones. Mr. Jones, you're before the court this morning on 2 charges. Count 1, burglary of an unoccupied conveyance, unarmed. Count 2, loitering or prowling. I find probable cause.
I'm sorry, I have a quick PC argument for that.
Go ahead.
Currently, he was arrested for burglary of a conveyance, unarmed. I reviewed the PC, and there's no facts in the PC alleging that he actually entered a vehicle. It's my position that it's simply an attempted burglary conveyance at best.
State.
I'll defer to the court.
All right, I will find probable cause for attempted burglary, and I am finding probable cause for loitering or prowling. All right, State, I'll go to you first for recommendation.
Judge, I don't see any criminal history on Mr. Jones. I do note that it does state that he has 0 months residence. However, he is born in Fort Lauderdale, so I'm not sure if that's accurate. I'd be asking Judge for a $5,000 bond on count 1. That's the attempted for conveyance. And a $500 bond on the L&P. And Judge, obviously no return and no contact with the alleged victim in this case, who is Mr. Hoover. I just would also note, Judge, that it appears that there is a co-defendant, Kelvin Clark, which I believe is the next person on the docket.
That's correct.
The arrest happened the same time, same place. Essentially, I'd just be asking for no contact, direct or indirect, with Kelvin Clark.
Judge, given the defendant's complete lack of a criminal history and from speaking with Mr. Jones, he advised that he is a lifetime resident of Broward County, I would be requesting an ROR to standard pretrial, given that this is his first criminal offense and he's presumed to be innocent of these charges.
The allegations that have been presented would be very serious on what I would consider to be a normal or average day here in Broward County. However, right now, we find ourselves in a state of emergency. I do see that Mr. Jones does not reside in Coconut Creek, where he was arrested. It appears that he resides in Fort Lauderdale, and this happened essentially in the middle of the night. Given the present circumstances that we find ourselves in, I do find that that is very aggravating in light of the allegations that have been presented today. As a result of that, I am not going to grant an ROR and place Mr. Jones on pretrial this morning. I'm going to set the bond on count 1 at $3,000. I will not place a bond on count 2. I'll leave that as essentially it's an ROR. There will be an order of no victim contact as well as a no return order. Mr. Jones, whether you know the alleged victim or not in this case, that means that you are not to go to or return to the residence that is at issue in this case. You are not to be in the same place at the same time as the alleged victim in this case. There are to be no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, thank you, sir. Good luck.
Judge?
Yes.
I'm sorry, you said $3,000 on count 1 and ROR on count 2?
Correct, there's no bond attached to count 2 presently.
Judge,
I'm going to leave it at
would the
that.
court entertain my request for the no contact with Kelvin Clark, who is appears to be the co-defendant in this case?
Not at this time. I'm
Okay.
looking at the information in the probable cause affidavit. I don't think that's necessary. Thank you. Next will be Kelvin Clark.
Judge, I have PC argument as well.
Is it the same?
Yes.
All right, that's fine. All right, good morning, Mr. Clark.
Good morning.
Sir, you're before the court this morning on 3 charges. The charges as listed are burglary of an unoccupied conveyance unarmed during a state of emergency. Count 2, loitering or prowling. Count 3, false ID given to law enforcement. Defense will allow you to make your argument at this time.
PC. I would argue he was arrested for burglary on unoccupied conveyance. I would argue that the facts in the PC rise to a level of an attempted burglary conveyance, and there was no facts in the probable cause affidavit that anyone successfully entered a vehicle.
All right, in light of the same argument that was made in the prior case and the information provided, as to count 1, I'm going to find probable cause for attempted burglary. I am going to find probable cause for counts 2 and 3. Did you need something from me on that one? He's not on free trial. Okay. All right, in Mr. Clark's case, I will hear the parties' recommendations beginning with the state.
Yes, Judge, I see no criminal history in Broward County, and I don't believe he has criminal history elsewhere. The state would be making the same bond recommendations, Judge, for the attempt, which is a $5,000 bond. On the loitering and prowling, Judge, I'd be asking for a $500 bond, and for count 3, Judge, I'd also ask for a $500 bond. no contact with the victim, no return to the location. And the state would also be asking for no contact with Lorenzo Jones, who appears to be the co-defendant.
Defense.
Judge, given that this is essentially the same incident, and Mr. Clark has a similar lack of criminal history and permanent residence in Broward County, and the court set Mr. Jones's bond at $3,000, and I believe pretrial level 2.
I did not
Oh,
impose a
just a
pretrial.
just a $3,000 bond, Judge. Since the court set a $3,000 bond for Mr. Jones and Mr. Clark's situation is very similar, the defense will be asking for a $3,000 bond for Mr. Clark.
All right. My position stands in Mr. Clark's case as it did with his co-arrestee's case. I will impose a bond of $3,000 on count 1. There will also be an order of no return and no victim contact. Mr. Clark, understand whether you know the alleged victim or not, you are not to go to or return to this location. You are not to be in the same place at the same time as the alleged victim. There are to be no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand?
Yes, ma'am.
Thank you. All right. Did you have an opportunity to review the PC for John T. Cax? Okay, are you ready to proceed on that? Okay, all right. So on Mr. T. Cax's case, are you going to waive his presence for both probable cause and bond?
PC, I can't do the bond because I haven't been able to speak to him regarding information related to the bond.
We could roll both.
We'll just reset him. I'm gonna
that's
have you
fine.
just talk to your office about it because they've
I will.
had a different position. Okay, so we'll reset Mr. T-Cac's case to tomorrow. We'll see what you guys want to do. All right, next will be Lewantarius Peterson.
Main jail is approaching.
Thank you. Good morning, Mr. Peterson.
Good morning.
Mr. Peterson, you're before the court this morning on 3 charges. Count 1, battery on a law enforcement officer. Count 2, resisting an officer obstructing with violence. Count 3 is trespassing on an occupied structure or conveyance. I find probable cause, and I will hear the parties' recommendations, beginning with the state at this time.
Yes, Judge, as far as the defense criminal history, in 2015, the defendant was adjudicated, served 90 days Broward County Jail for possession of PVP. He was adjudicated time served on a trespass in 2014. Additionally, in 2014, he received 180 days Broward County Jail for possession of cocaine, which is 143783 CF10A. There is a prior resisting without violence in which the defendant received an adjudication time served, it appears, Judge, which is 142952 CF10A. That came with it a possession of cocaine in which the defendant received 180 days Broward County Jail followed by 4 years probation. There's various trespasses in the defense criminal history, mostly controlled substances, Judge, and giving false names to law enforcement. The state would be asking, Judge, for a $3,000 bond onto count 1 and to count 2 and standard pretrial.
Judge, defense will be asking for our ROR to standard pretrial on all counts. Mr. Peterson is unable to afford the bond. Mr. Peterson does have charges in his past, but as the state said, they are mostly possession charges. The other ones sound like misdemeanor charges, and given the lack of a serious criminal history and the fact that Mr. Peterson advised that he has always shown up for court, we would be asking for an ROR, the standard pretrial.
Judge, I see 5 violations of probation in the defense criminal history.
Well, in light of that history, I'm not going to grant an ROR today. The bond on count 1 will be set at $1,000. Count 2 will be an ROR, and I'll leave the $100 bond in place on count 3. I'm not going to place Mr. Peterson on pretrial. However, there is going to be an order of no return to the Quick Stop food store that is at issue in this case. Mr. Peterson, that means that you are not to go to or return to that location. Do you understand that?
Man, I ain't got no money to be paying.
Mr.
man.
Peterson, do you understand the no return order I've just explained to you?
Yes, ma'am.
Thank you. Good luck.
Excuse me. Ma'am,
Yes, Mr. Peterson.
I have no money to pay. I don't have no money.
Okay, well then, Mr.
I'm homeless,
Peterson, you can
man.
discuss that with your attorneys after today's hearing. Thank you. Next will be Justin Swain. All right, good morning, Mr. Swain.
Good morning, ma'am. Ma'am, I haven't had a chance to speak to my lawyer yet, ma'am.
One moment. Were you able to speak with Mr. Swain this morning? Okay, all right, Mr. Swain, I'm gonna have them call you on the phone to speak to you privately, and then I'll call you back up. Thank you.
Okay, thank you.
Next will be Sean Feather.
Mangel,
Thank you. Good morning, Mr. Feather.
Good morning.
Sir, you're before the court this morning on 3 charges. Count 1, resisting an officer, obstructing without violence. Count 2 is trespassing on an unoccupied structure or conveyance. Count 3 is a felony probation violation which has a no bond hold. I find probable cause. In light of the no bond hold, is the state seeking anything beyond the $100 bond on count 1?
No, ma'am.
All right, does the defense have any objection? Okay, all right, so Mr. Feather, you're going to see your division judge within the next couple of days so you can address the no bond hold. Good luck to you, sir.
All right, thank you.
Next will be Philip Cunningham.
Mangel, he's approaching.
Thank you.
No, sir.
All right. Good morning, Mr. Cunningham.
Good morning.
Mr. Cunningham, you're before the court this morning on 5 charges. Count 1, aggravated assault with a deadly weapon without intent to kill. Counts 2, 3, and 4 are each a separate count for burglary of a dwelling structure or conveyance while armed. Count 5 is improper exhibit of a firearm or dangerous weapon.
There was no firearm there.
Mr. Cunningham,
Mr. Cunningham, I would advise not to speak.
I find probable cause for these charges, and at this time, I will hear the parties' recommendations. We'll begin with the state.
Yes, Judge. Currently, Judge, the defendant is charged with 3 counts of armed burglary. Those are offenses that are punishable by life. If the court were to find proof, evident, presumption, great, then the state would be asking that the defendant be held no bond on those counts. In addition to these cases before the court for bond, the defendant has an open 2017 Berg dwelling, which is 171754 CF10A. It's a Berg dwelling, a Berg conveyance, a grand theft auto, and resisting without violence. In addition to that, Judge, the defendant has a 2011 delivery of cocaine, 3 counts of delivery of cocaine. He was adjudicated, sentenced to 2 years probation on those cases. And that is the extent of his Broward County criminal history.
The 2017 case is pending now.
Yes, Judge, that would be before. I can get that for you right now.
Is he out on bond in that case, or is he on pretrial, or what?
It's in front of Judge Lynch, Judge. He posted a $1,500 bond on count 1. Count 2, he posted a $1,000 bond, and count 3, he posted a $3,500 bond.
What's the case number?
That's 171754 CF10A.
All right, and the state is seeking a finding of proof, evident, presumption grade on counts 2, 3, and 4 in this case?
Yes, ma'am.
All right, first I'll go to the defense for their response to that request.
Say you do not find proof, evident, presumption great. And the reason is a review of the PC does not reveal that they found any firearm. The only description as to the firearm was a, quote, black handgun. There's no other descriptive items related to the handgun. It's not clear whether or not there was actually a firearm or, in fact, there was a weapon Based upon that alone, I'm asking that you do not find proof evident presumption great.
All right. To begin, the court is going to sua sponte revoke Mr. Cunningham's bond in the 2017 burglary of a dwelling case that he is out on presently. That is, for the record, once again, case number 171754 CF10A. I am going to order that he be held no bond in that case until his division judge decides how he would like to proceed. In the case that is before me today, I have reviewed the probable cause affidavit in this case, and based on the information that has been provided to me, at this time, the court is going to make a preliminary finding of proof evident presumption great and order that Mr. Cunningham be held no bond on counts 2, 3, and 4. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge to further address that matter. Though he does have the no bond hold, I will hear the party's recommendations on count 1 at this time.
Judge, as I stated before, the defendant does have a criminal history that is lengthy in Broward County. The state would be asking for a $5,000 bond on count 1, and with pretrial level 2, no contact with the victim, no return.
All right, the bond on count 1 will be set at $5,000. Though Mr. Cunningham is presently being held no bond, in an abundance of caution, there will be an order of no victim contact, as well as an order that he possess no weapons, firearms, or ammunition. Mr. Cunningham, with respect to the no victim contact order, that means you are not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person, and no third-party contact or social media contact. Additionally, there is an order that you are to possess no weapons, firearms, or ammunition. If you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand everything I've explained to you?
Yeah, but there wasn't never no firearm. That's what I'm saying. With no
Sir, please
firearm.
stop speaking about your case, and I'll invoke his right to remain silent this time.
All right, thank you. All right, thank you, Mr. Cunningham. Good luck, sir. All right, are we ready to proceed on Mr. Swain's case?
Yes, Judge, we're ready.
All right, let's bring Mr. Justin Swain back up, please. All right, thank you. Okay, Mr. Swain, you're before the court this morning on 2 charges. Count 1 is...
I haven't had enough time to speak to my attorney. I'm sorry to interrupt you again.
Mr. Swain, you just spoke to the attorney on the phone.
The phone went off. I did not have enough time to finish talking to my attorney, ma'am. Yes, ma'am, I just haven't. I'm not
Mr.
meaning to
Swain,
interrupt you again.
one moment. I'm waiting to hear from the attorney.
Mr. Swain, if I need to take some information from you, I could just ask you through this microphone, okay?
All right.
All right.
All right. Now,
Yes, sir.
Mr. Swain, you are here this morning on 2 charges. Count 1 is second-degree petty theft, third or subsequent offense. Count 2 is corruption by threat to a public servant. I find probable cause, and at this time, I will hear the parties' recommendations. We'll begin with the state.
I'm sorry, Judge, you guys said one moment was looking at the wrong person.
Go ahead.
Judge, the defendant has a lengthy criminal history in Broward County.
Okay.
There is a 2019 exposure of sexual organs that's still filed. It looks like it was filed on November 26, 2019. That's 19-11016 MM10A. The defendant was received an adjudication 364 days Broward County Jail on March 25, 2019 for felony petty theft. He had a second felony petty theft in 2018, a criminal mischief in 2018, of another felony petty theft in 2017, third-degree grand theft in 2017, felony petty theft and felony petty theft in 2017, 2 counts of felony petty theft in 2016, a grand theft in 2015, another grand theft in 2015, another grand theft in 2015, separate grand theft in 2015, petty theft in 2015, grand theft 2015, felony battery, Judge, in 2013, which the defendant received 20 months Florida State Prison. He also received 20 months Florida State Prison in 2012 for robbery by sudden snatching. He has 3 counts of battery in 2009, in which he received an adjudication, 159 days, Broward County Jail. This was also a violation of domestic violence case on the same case, which is 2009. It's 0929036 MM10A.
Okay, what's the state's recommendation?
Judge, for count 1, the state would be asking for a $5,000 bond. On count 2, the state would also be asking for a $5,000 bond.
Mr. Swain, is there any amount of bond that you can currently afford?
No, sir.
And Mr. Swain, do you have an address that you would be living at if the judge were to release you?
Yes, sir.
And
My mom's address.
okay. And this is obviously not related to this case at all, right? She's not an alleged victim?
No.
And how long have you lived in Broward County for?
All my life, 35 years.
Okay. Thank you, Mr. Swain.
All right.
Given that Mr. Swain is a lifetime resident of Broward County and he does have an address that he would be able to stay at, we would be requesting an ROR to pretrial level 2 with a GPS monitor. I understand that that he does have a lengthy criminal history, but I don't believe the fact that he's indigent should keep him in custody.
Judge, the defendant was just arrested on February 11, 2024. Multiple felony petty thefts. The state did no info then, but the defendant continues to be arrested constantly.
Did he post bond in that case?
No, Judge. Let me get his bond information there. Yeah, Judge, it does look like he posted a $750 bond on 1, 2, 3, 4, 5.
Mr. Swain, no, I'm listening to the state attorney right now.
Back to Odyssey. It looks like he posted bond on at least 5 counts of felony petty theft for $750. But I can't verify that. It just, that's what it looks like.
All right, and Mr. Swain, did you want to tell me something just about that?
Yes, ma'am. I did not post bond. I was ROR.
All right, you have a copy?
Judge, I'm sorry. There is an order from, afterwards, Judge, March 16th, in which Judge, you, did grant the motion for ROR a month after he was arrested.
Oh, it's because they weren't filed.
Right.
What date was he released?
$16th or $17th. Let me just verify.
He was released on March 16th. All right, in light of that information, I am going to leave the $750 bond in place on count 1. I will set a $500 bond on count 2. There is going to be a no return order to the CVS location in Hollywood that's at issue in this case. And there will be an order that Mr. Swain possess no weapons, firearms, or ammunition. Mr. Swain, that means if you are in possession of any of those items, They are to be surrendered to local law enforcement until further order of the court. And understand that the no return order means that you're not to go to that CVS location. Do you understand that, sir?
Yes, ma'am.
All right, thank you. Good luck, sir.
So what's my bonds at right now? 750 and 500?
Correct. Thank you. Thomas Egan.
Main jail, he's approaching.
Thank you. Good morning, Mr. Egan.
Good morning.
Mr. Egan, you're before the court this morning on a felony violation of probation. I find probable cause. And Mr. Egan, this has a no bond hold, which means that you'll see your division judge within the next couple of days so you can address that issue with them.
Judge,
Yes.
I'm sorry to interrupt, but Mr. Egan did speak with me. He said that his division judge was Judge Casey, and he advised me that that Judge Casey told him that he was actually supposed to be released ASAP. I believe the violation was just for restitution. He seems to be under the impression that Judge Casey told him that he was going to be released today.
Well, I'm looking at the warrant, which has a no bond hold on it, so Judge Casey will have to be the one to address that issue. Additionally, this order was signed by Judge Calra, not Judge Casey, so I'm not sure if there's another case perhaps that I'm just not aware of. Okay, all right. Thank you, Mr. Egan. Good luck, sir.
Thank you.
Next is John Toomey, and he's still medical, right? Okay, thank you. Next is Christopher Pinkney. Is he still medical?
Medical reset, ma'am.
Okay, thank you. And next is Jermaine Arthur. Is Mr. Arthur still a medical reset? Yeah,
Yes, ma'am.
okay, all right. We have to have him, I've already found probable cause, we have to have him reset for bond. All right, so now let's go to our hearing docket. I have one misdemeanor case that's on the second look, and that is for Javon James.
Thank you, Your Honor.
Thank you. All right, good morning, deputy. Okay, good morning, Mr. James.
Yes, ma'am.
All right, Mr. James, I have you here on a second look today. It looks like we've got just the misdemeanor case is set.
Yes,
So
ma'am.
I see that the bond on the misdemeanor is currently set at $250. Let me just go to confinement. Can you tell me the felony charge that that Mr. James had? Did he post a bond on that, or what's going on? He was given pretrial just on the felony case? Standard pretrial? Okay. All right, so let me go to the defense first.
Judge, well, given that he's on standard pretrial for his felonies, I would just be asking for him to be ROR to standard pretrial in this case as well. I would like to add that that Mr. James is taking care of his mother. She is partially blind and she has diabetes. He's helping with her bills, and he has lived in Broward County for a very long period of time, at around 30 years, Judge.
Okay. Does the state have any objection to me placing this on pretrial with his felony cases?
That's fine, Judge. I don't know if the defense had an opportunity. I was willing to offer an adjudication time serve on this case if you wanted to take care of it today.
Yes, I like that.
Mr. James, would you like to take that?
Yes, sir. Time, sir.
That's on his misdemeanor case only,
Okay.
Judge.
It's an adjudication time served.
On your misdemeanor?
Yes.
And you're aware that this is going to add 0.2 points to your score sheet?
Yes, sir.
Okay.
Okay, is this, are you able to tell me, because I see this is a driving while license suspended, is this his, does he have any priors? I just need to make sure he's,
Oh, 1 second, Judge. I'll pull his DL. I think this would be his third, Judge, if I'm reading this correctly.
this is gonna be the third?
I believe so, Judge.
Okay, well, if it's his third, then I need you to let me know if that's gonna trigger the 10 days, because if it is, then I'm not gonna take the plea.
I think it would, Judge.
All right, so, okay, that's probably why it wasn't played out before. Mr. James, since this would be your third driving driving with license suspended, then it would trigger a mandatory 10 days in jail. So unless you are willing to accept an offer that includes 10 days in jail, then I'm willing to place this on pretrial supervision with your other cases. So what would you like to do?
You can run it concurrent.
I'm sorry?
You can run it concurrent with my other cases.
Well, your other cases are on pretrial supervision. So if I put this case on pretrial supervision, that means that you would be released today, and you would have to just comply with whatever your pretrial requirements are.
Okay, I'll take that deal.
Okay, all right. So then what I'll do is I'll sign an order. I'll place an ROR on this charge and place this on standard pretrial supervision with the other charges. Okay? All right, so Mr. James, as long as there's nothing else holding you, then you'll be released to pretrial supervision. On this case, just like with the other ones, you just need to know that you have to report to pretrial supervision within 24 hours of your release. The deputy will give you a piece of paper with instructions on where you need to go. It's very important that you understand that the pretrial office is closing early each day, so you have to be there before noon. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
You're welcome. Thank you. All right, now we're going to go over to our felony hearing docket. First up will be Brandon Bass. Which facility is Mr. Bass at? Sheila, can you tell me where Mr. Bass is? Oh, thank you.
Sorry, what was it?
All right.
That's it. Oh, this is so. Yeah. Oh.
North Broward, do you have Brandon Bass?
The case has been declined, Judge. That's 22.
So is he already released?
Let me double check.
He has an out-of-state home, but the one that he's here for is CPR.
Yes.
Yes, I'm just confirming that everything's been declined. Yes, declined. So yeah, he'd be ROR.
All right, well, I'm not sure what's going on with North Broward, but Mr. Bass is going to get the ROR in this case. So somebody let North Broward know and I'll sign the order. Next will be Eric Selman. Which facility is Mr. Selman at?
It's failure to register.
Your Honor. He's not here at the moment, but I do have Delvin Williams.
Okay, I'll go ahead and go to Mr. Williams then, if you'll bring me Mr. Selman also.
All right, thank you.
Thank you.
Looks like we're about to.
Yep, Delvin Williams is up next.
Yes,
All right,
ma'am.
good morning, Mr. Williams.
Yes.
All right, Mr. Williams, you're here on a 30-day motion today, so state, tell me if the charges have been filed or not, please.
Yes, Judge, just one moment. I'm taking a
Okay.
look. Judge, I see no information filed.
Charges have not been filed? Is there
No.
anything else holding Mr. Williams?
Someone's going to be filed.
That
the
on
rest aren't
Williams?
filed. No, Judge, I'm just looking really quickly. I'm sorry. Nothing should be holding them. Just double checking. Delvin. No, Judge.
All right, Mr. Williams, since the state
Yes.
has not filed these charges, that means that you're entitled to an ROR. If there's nothing else holding you, that means that you'll be released today.
Yes.
I need you to understand that although you're going to be released today, that doesn't necessarily mean that that's the end of the case. So
Yes, ma'am.
it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know if there are any future court dates you have to be present for. Do you understand that?
Yes, ma'am.
Okay, all right. Good luck to you, sir.
All right.
Thank you.
All right.
Okay, and next will be Dennis Bowler. Is Mr. Bowler at Conti also? Sheila, where's Dennis Bowler? All right, let's go back to North Broward. Has anyone spoken to anyone at North Broward? All right, well, I'm waiting on Eric Selman at Conti and Dennis Bowler at North Broward.
County facility, Selman.
Yes,
Approaching.
thank you so much. All right, good morning, Mr. Selman.
Good morning.
All right, Mr. Selman, you're here on a 30-day motion today. State, have the charges been filed?
No, Judge. You said Eric
This
Selman,
is Eric
Judge?
Selman.
Oh, I'm sorry, Judge. Let me just double check. 2148. Selman. No information. Judge, it looks like, I see that there's filing instructions that are going to be going to the clerk, so it looks like it's going to be filed today. But I don't see an information on Odyssey. What happened to saves?
Well, if it has been filed, then I need the e-filing number if it's not showing in Odyssey, so.
Yeah, my whole computer just died on me. 1 second, Judge, I'll pull it up. Nope, not that one. 2140.
Okay.
Is this Sheila? Oh, it's Crystal Edwards.
Sorry, Mr. Selman, one moment. They're just confirming whether these have been filed or not. While we're waiting on that, did anybody speak to North Broward? Okay, thank you. On the Dennis Bowler, it's a 30-day motion. To address, and as soon as he's there, I'm doing it. If they're not ready by the time we're done, then you know what's going to happen. All right. Mr. Selman, I'm going to place your case on a brief recall. I'm going to go to my last hearing, and then I'll call you back up, okay?
Your Honor, today's 36 days, am I correct?
Mr. Selman, I'm not sure what day we're on here, but I've got the motion in front of me. I'm just waiting on the state attorney's office to confirm whether it's been filed or not. So while they're getting that information, I'm going to go to my next hearing, and then I'll come back to you, okay?
Okay, thank you.
Thank you. All right, let me go to North Broward. And at North Broward, we're just waiting on Dennis Bowler.
Oh, that's our one.
Good morning.
Good morning, Deputy.
How are you?
I'm hanging in there. How are you?
All right, I have Mr. Bull on his way down.
Okay, thank you so much. Do you need a few minutes or what?
Yeah, just until he gets here.
Okay, because what I can do is,
It's on its way.
okay, I can just go off camera for a few minutes, and if you would, can someone just call the attorneys here in the courtroom when you're ready?
Okay.
All right, we'll just go on a brief recess. We're waiting on these last two cases, and then I'll come back on when we're ready.
Okay.
Thank you. All right, we're back on. I'm gonna go back to Conti on Mr. Eric Selman's case, if we could bring him back in. Thank you, Deputy. All right, Mr. Selman. All right, State, did you confirm if the charges have been filed in Mr. Selman's case?
Yes, Your Honor.
Yes, they have been filed?
Yes, they've been filed.
What's the filing number?
105-59-5530.
5530?
Yes.
All right. All right, Mr. Selman, since the state has confirmed that the charges were filed as of this morning, that means that your next step in that case will be to go before your division judge for an arraignment hearing. All right? Good luck to you, sir.
Your Honor, could I get a bond reduction?
What's the bond currently set at Mr. Selman's case?
$7,500.
Is that just on count one?
Yes.
All right, Mr. Selman, do you have a permanent address?
$1251 Southwest 51st Terrace, Plantation.
Whose house is that?
It's my boss's.
Your boss's house?
Yes.
All right.
He's the one that, he has glaucoma, he already lost one eye, and it's only me and him doing a lawn care service.
Okay. Are you able to afford any monetary bond at all?
No, not at all right now, because I've been locked up 36 days. I was wondering if I can get an ROR. I've been here since 2007.
All right. State, give me a rundown of Mr. Selman. Does he have any other priors?
Judge, I have a 2010 failure to register as a sex offender. He adjudicated, received 2 years probation, and 3159, 5 CFA. There's also 555 and 10A. Defendant was adjudicated and received 90 days in jail.
That was in 2014?
Yes, ma'am. That's the extent of his Broward County criminal history.
All right. Do you have any objection to him being placed on pretrial supervision with a GPS monitor?
Pretrial 2?
Mm-hmm.
That's fine, Judge.
Defense? Anything you want to add? No. All right, Mr. Selman, the number one, the 30-day motion is going to be denied since the charges were filed. I will place you on pretrial supervision with a level 2 GPS monitor. I just need you to understand that that's going to be, pretrial is going to have to verify that that's the address that you're going to be staying at before they're able to fit you for the GPS monitor. Do you understand?
Yes.
Okay, all right, so they'll get that information from you. If for any reason they are unable to verify that address, then the bond will remain as it was set. You understand that?
Okay.
Okay, all right, thank you very much. Good
Thank
luck.
you very much. Thank you, State.
All right, let's go to North Broward. North Broward, please tell me that you have Dennis Bowler.
Still waiting for him to arrive, Your Honor. But I do want to apologize. I did see the email where we will be doing this from here on out.
Yeah, we have
So,
single session starting today.
So I'll be prepared.
Okay, do you have an ETA on him? Because I have to be done by 11:30.
Yeah, I just called and they said that he was en route. So, and it's only
Okay.
2 minutes away, so.
All right, I'm going to stay here on the record now because IT thought we were done actually a few minutes ago and took us off. So I'm going to stay on. If you could please have them get it to me as quickly as possible. He's my last one.
Okay.
Thank you.
All right.
Cleans the toilet. I bet you it is. I bet you that's true.
Thank you very much.
Yeah, have you, yeah. Ever get cancer from using
So Lorna Rent's gonna be doing it at 11:30, then from now on, here? Is that, who does it 11:30?
I'll tell you when I get done.
Oh, sorry, I forgot we're on the record. Sorry.
Thank you. All right, good morning, Mr. Bowler.
Good morning.
All right, Mr. Bowler, you are here on a 30-day motion today. I see that we have Mr. Bowler set twice on the docket this morning. So let me first go to the state to put everything on the record. What's going on in Mr. Bowler's cases, state? Just speak into the mic, please.
Sorry, Judge. Mr. Bowler currently has 2 open cases. One of them he would be entitled to an ROR.
Okay.
The second one he would not be entitled to an ROR because it has not been the 30 days have not told yet. The case that he is entitled to an ROR is 20-2205 CF10A.
That's the one that has the criminal mischief and trespassing charges?
Yes, ma'am, in front of Judge Siegel.
All right.
The second case is 20-2439 CF10A,
Okay.
also in front of Judge Siegel. That's arson in the first degree, criminal mischief, and 2 counts of criminal mischief, over
All right.
$1,000.
Okay, so Mr. Bowler, a couple of things that we have to discuss, okay? On your second case, it looks like there's 3 days left before this motion actually will become timely because those charges were added later on. So we'll have to revisit that in a couple of days to see whether the state has filed the charges or not. On the first case that has the criminal mischief and the trespassing charges, on that one, they have not yet filed the charges. So you are entitled to an ROR, but that is with the understanding that you're going to remain in custody while these other cases are pending. So you can either take the ROR, or if you would like for me to leave it as is, then you will continue to accrue time served on those. So what would you like to do?
I accept the ROR.
You want to take the ROR on those?
Yes, ma'am.
Okay, all right. Then, Mr. Bowler, I'm going to grant you the ROR on, let me just say once again for the record, that's case 20002205 CF10A. I'll grant the ROR on that one, and then I'll see you back here in a few days so we can address the other case, okay?
Okay, yes, ma'am.
All right, thank you, sir. Good luck to you.
Thank you.
Thank you. All right, that brings us to the end of our docket for the day. As we briefly discussed earlier, for the time being, we are going to be on a 1 docket session per day schedule here in Magistrates until we have another change in schedule. I'll try to keep everyone apprised of that, but for the time being, our morning sessions will begin at 8:30 and there will be no additional afternoon session. So that's going to be it for today. I'll see everyone back here tomorrow morning. Thank you very much.